Mr. Green, are you able to hear me okay?
Yes, I am.
All right, we'll go on the record in People versus Eric Ball. This is file number 236597, although we have a number of matters for Mr. Ball up for hearing today, but this is the child support matter. If I could have counsel put your appearances on in this file.
Good morning, Your Honor. Jesse Green, Special Assistant Attorney General, here on behalf of the people.
Thank you, Your Honor. Richard Trishkring on behalf of Mr. Ball.
All right, this is the date and time set for sentencing hearing on a delay in this file. I don't see Mr. Ball here. Have you had contact with him today, Mr. Trush?
I have not. I did receive an update from friend of the court that there was a hearing scheduled in regards to the outstanding arrearages. What Mr. Brzezinski indicated to me was that Mr. Ball did not appear for that hearing. So there's been no change in the amount of the arrearages. Since that time, I haven't had any contact with Mr. Ball.
All right, Mr. Green, it would be my intention then, given Mr. Ball's failure to appear here this morning for his 9 o'clock hearing, his failure to appear before friend of the court, be my intention to issue a bench warrant for his arrest and then proceed further once he's brought before the court. Did you have a different position than that?
No, Your Honor. Just one thing in addition to that, we would ask that no bond be set when he is apprehended.
Okay, Mr. Trush, anything on that issue?
I suspect that any argument I have is going to be rendered moot by the subsequent hearing.
Yeah. Okay. So, Mr. Green, I agree. You know, this is for sentencing, so I don't believe Mr. Ball in any case would be entitled to further pretrial release. And I think, given the status of this case and the proceedings up till now, it would be appropriate to hold him without bond until we can get a sentencing hearing scheduled. Once that happens, the court will notify your office, and if counsel from your office, Mr. Green, wants to appear by Zoom, just notify my assistant Jennifer that prior to the hearing.
Thank you, Your Honor.
Mr. Green, anything further on this file today?
No, Your Honor. Thank you.
Mr. Trush?
Nothing further.
Okay, thank you, Mr. Green. You're free to disconnect at this time.
Thank you. Have a good morning.
Are we in order for that?
I'll have, so for the record, the AG's office is already disconnected. For the record, I'll ask Jennifer to contact the AG's office to prepare the bench warrant in this case. Okay, and then we have a number of other files set for final status conference today with Mr. Ball. File number 246733, 6734, 6746, 6771, 6772, and 6788. I have counsel for their appearances on each of those.
And a prepared hearing on behalf of people.
Thank you, Your Honor. Richard Trishkring on behalf of Mr. Ball.
All right, and again, this hearing was set for 9 a.m. It's 9:05. Mr. Ball is not present here in the courtroom today on these files either. This is set for a final status conference today. We have a trial set for later this month. And I've received, it's been signed yet. Is the stipulation been signed to adjourn?
We had prepared a stipulation to request an adjournment due to the fact that I called for federal jury to be the next 2 weeks. Mr. Trush and I have been attempting to resolve this case and working towards plea negotiations. Mr. Ball is not here today, so we still are. I anticipated coming to court today asking for adjournment of next week. Given Mr. Ball is not here today, I'm anticipating this court's not going to call a jury in next week anyway. I would ask that the court issue a bench warrant as well in this case.
Mr. Church.
The only update I would indicate in regards to that, the background that the prosecutor laid out is accurate. I don't think the stip ever got signed because I was never able to get in touch with Mr. Ball. So it wasn't clear to me if we needed to adjourn it, if we were going to have a resolution, or if he had a reason to oppose the adjournment. So again, I'm not going to take a position opposing anything today, but that's just a procedural background.
All right, I think regardless of whether there's a stipulation, I think we have good cause to adjourn the trial date for two reasons. Number one, I find Ms. Krueger's obligation for federal jury duty would be good cause to adjourn this trial. I did inquire through my staff whether or not the prosecutor could have a different attorney handle these cases. And I believe it's the people's position as Krueger that due to the number of files and the complexity of the nature of the charges that at this point would be practical for a prosecutor to step in. Is that fair statement?
That's correct, Judge. I've handled these cases from the beginning, down to preliminary exams in district court through a number of victims and witnesses. And it's just a case I prefer to continue handling through trial.
Okay, so I find that that would be good cause to adjourn the trial. Also, now we have the added issue of Mr. Ball's failure to appear here today. And so the court is going to, Ms. Krueger, request a bench warrant as to these files as well. And Mr. Ball, for his failure to appear today, the court will adjourn the trial dates based on his failure to appear as well as the prosecutor's reasons. We'll set further hearings once Mr. Ball is arrested before the court. So both parties can take those trial dates out of your calendars as well. So, Ms. Krueger, anything else we need to address in this file?
No, Your Honor.
Mr. Church.
No, Your Honor.
Okay, our next hearing set for 9:15. Mine's here yet.
I have not seen this working yet. I would indicate, we did discover she was in Sheboygan's jail last week. I was then notified on Friday that she bonded out there.
Okay.
So I do expect her here.
Okay. All right. We're ahead of the docket, so we'll take a short recess and back in record.
All right.
I know, I was like, I thought it took something.
Thank you. Mr. Woodworth, are you able to hear me okay?
Yes, Your Honor.
All right, we'll call People versus Michael Woodworth. We have file number 256797 and 256799. And then Mr. Trush, you asked the court to also call 6798. Is that correct?
Correct, Your Honor. I didn't realize it wasn't up for today, and we're prepared to address them all.
Okay. So we'll go forward on all three files today. And can I have counsel for your appearance?
Good morning, Your Honor. For the record, Mike on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Woodworth.
Thank you, Mr. Trush. How do we want to proceed on these files this morning?
Thank you, Your Honor. We have a global resolution that should resolve all three matters.
I'm sorry.
Yes, Your Honor.
Sorry, go ahead, Mr. Trush.
It contemplates in 256797 as well as 256799. And both of those files can be plain to a retail fraud first as a habitual second offender. And then in 256798, it'd be plain to the resisting and obstructing as a habitual third offender. The remainder of both complaints would be dismissed. Or I'm sorry, all three complaints would be dismissed.
Mr. Bill, is that a correct statement of the plea offer?
It is with restitution as to Meyer in the amount of $1,102.66. That's 1102.66.
Mr. Trush, as to the restitution.
I don't have an objection to it, but I was under the belief it was to Walmart, not mine.
Actually, Walmart was covered. Meyer is the one that did it.
All right, Mr. Woodworth, were you able to hear what the attorney stated regarding the plea agreement?
Yes, Your Honor.
And have you discussed that plea agreement with your attorney, Mr. Trush?
Yes, Your Honor.
Did you want to go forward with that plea agreement today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Woodworth, are you currently on any kind of probation or parole?
No, Your Honor.
Mr. Truch, were any of these offenses occur? Did any of them occur while Mr. Woodworth was on bond?
I don't believe so. I think he was arrested for all three offenses effectively at the same time.
Okay. So, Mr. Woodworth, I'm going to go through the maximum possible penalty on each of the charges that you're going to plead guilty to today. The first one is 1 count of retail fraud first degree. As a second habitual offender, the maximum possible penalty you could face for that charge would be up to 7.5 years. Do you understand that?
Yes, Your Honor.
And then also the second count, the same charge and same maximum penalty in a second count of retail fraud first degree as a second habitual offender. Again, the maximum possible penalty would be up to 7.5 years. Do you understand that?
Yes, Your Honor.
And then as to both of those files, you could be ordered to pay restitution and fines and costs. And that even though it sounds like there's an agreement as to the amount of restitution, by statute, you could be required to pay up to $10,000 or up to 3 times the value of the property that was stolen. Do you understand that?
Yes, Your Honor.
And then finally, you're going to plead guilty to 1 count of resisting or obstructing a police officer as a third habitual offender. The maximum possible penalty you could face for that charge would be up to 4 years. Do you understand that?
Yes, Your Honor.
With all of those penalties in mind, what is your plea to each of those charges today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. The only way to appeal it is by leave, and that means that you have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anybody promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty of these charges?
Yes, Your Honor.
Mr. Church, are you prepared to do the questioning on this to establish a factual basis?
I could do that. Mr. Woodworth, were you here in Otsego on November 4th of 2024?
Yes.
And were you at the Walmart here in Otsego County on that date?
Yes.
And on that date, did you take some merchandise pushed out of the store in a cart?
Yes, sir.
And it was your intentions to take that merchandise?
Yes.
And if I were to tell you that merchandise had a value of $732.04, would you have any reason to think that's incorrect?
No.
Had you previously been convicted of a retail fraud offense?
Oh, okay, yeah, right.
Were
So you
you?
gave me the dollar amount, right? You have to correct the record then.
Well, no, this is Walmart.
Oh, okay, all right.
Had you previously been convicted in 2023 of a retail fraud offense here in Otsego County?
Yes.
Okay. And had you previously been convicted of a domestic violence offense in 2018 here in Otsego County, a felony domestic violence?
Yes.
I think that would establish the factual basis for that file.
Any objection to that, Mr. Rowland?
No, Judge, people satisfied. Thank you.
And then on or about December 29th of 2024, were you at the Meyer here in Otsego County?
Yes, Your Honor. Yes, sir.
And on that date, did you take items that were offered for sale at the store?
Yes.
And if I were to tell you the items that were taken on that date were valued at over $1,000, would you have any reason to dispute that?
No.
And likewise, on that date, you had previously been convicted of that domestic violence felony here in Otsego County?
Yes.
And then I think that would establish the factual basis for that charge.
I do got one question though. On the Meyer stuff, when they did arrest me, they did get back the stuff. They took it right from the house.
All right, so Mr. Woodworth, that's something, I mean, I know we've discussed restitution as part of the plea agreement. Ultimately, the amount of restitution is on the burden of, people have the burden of showing the amount. So if there's a discrepancy there, we can address that at sentencing. And Mr. Woodworth, you have the right to contest the amount of restitution. So if it's not correct, that's something that you'll be able to discuss with your attorney and to raise that in front of the court at sentencing, okay?
Okay.
So
thank
we'll
you,
talk,
Your Honor.
we'll talk about.
69798.
Oh, I'm sorry. So was there an agreement that provides a factual basis for that charge?
Right. Aside from the restitution issue.
Yes, Judge, it's not, and I believe Mr. Should get those property offers for sale. If he did not, that is a condition that his property was up for sale from, in this case,
Myers.
Myers store.
I think we've established the factual basis. So.
With that, Judge, then people are satisfied. Thank you.
Okay.
Okay, and then Mr. Woodworth, on December 28th of 2024, did you come into contact with some police officers?
Yes,
And had they come to your home to arrest you?
yes,
When they came to your home, did they give you some commands?
yes,
Did you immediately comply with those commands?
no, sir.
And the officers, they were in full uniform and they announced themselves as officers?
Yes,
So you knew they were officers?
yes, sir.
Is your home located within Otsego County at the time?
Yes,
And then on that date, you, again, had still been previously convicted of that domestic violence felony in Otsego County?
yes,
And in addition to that, did you have a controlled substance felony in 2019? Again, here in Otsego County?
yes,
I believe that would establish a factual basis for the third file.
Mr. Rowland?
People are satisfied. Thank you.
Okay. Mr. Rowland, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
None by the people. Thank you.
I'm aware of none, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in taking this plea?
Yes, Your Honor.
Mr. Church?
I'm satisfied.
Mr. Woodworth, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, someone from the probation department will be contacting you to prepare a pre-sentence report. You'll have a chance to go through that with your attorney prior to the sentencing hearing.
Your Honor, if I may, we were going to ask for 60 days for sentencing instead of 30. Mr. Woodworth believes that he can pay the restitution before the sentencing date. But he'll, because it's a fixed income, he'll need 2 checks to make that happen.
Mr. Rowland,
No objection. And just so the record's clear, the amount of the restitution is for property taken from both Meyer and Walmart. So if that goes to the restitution, that would be the issue. Thank you, Judge.
all right, so we'll set it out 60 days. Mr. Trush, anything further on this file today?
No, thank you.
Mr. Rowland.
No, Your Honor. Thank you.
Okay, thank you, Mr. Oh, we do have trial dates scheduled for June 27th. Court will adjourn the trial dates and leave today.
Very good. Thank you.
I think the R&O file that was up, I think also has trial dates somewhere. I'm not sure where they're at, but I think that's on the trial docket as well.
And
Okay,
Judge, that was one of the ones that was not consolidated to retail fraud, so it was set for a later date.
separate, okay.
Thank
So
you.
we'll also adjourn that one. Okay, thank you. That's all for today, and we're going to disconnect from the jail.
Thank you, Your Honor.
Sir, is your name, let's see, Kenneth Krueger?
Yes.
Okay, Mr. Krueger, I'm just gonna put you on hold for a minute, and then we'll call your case. I have one other file I need to address prior to yours. Okay, Ms. Working, if you wanted to come forward, please, up to the podium. The court will call People versus Joanne Working, file number 256854. The record should reflect that Ms. Working present here in the courtroom today. I get a council for your appearance.
For the record, John, I'm going to go back to people.
Thank you, Your Honor. Richard Church on behalf of Ms. Working.
Mr. Trish, can you tell me the status of this file today?
Yes, Your Honor, we do have an agreement that I believe we're going to enter into today. In this file, Ms. Working would be admitting to count 1. In exchange for that, the habitual offender notice would be dismissed, as well as count 2. And somewhat academic, but the prosecutor also agrees that they wouldn't pursue any additional charges for R&O stemming from this incident.
Mr. Rolla, is that a correct statement of the plea offer?
Yes, Judge, in count 1, dismiss count sections 2 and 3, as well as individual.
Thank you. Ms. Working, have you had a chance to talk to Mr. Trush about this plea agreement?
Yes, sir.
And is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. Over again.
And I'm sorry, Your Honor, I meant to indicate this would be a no contest plea. She does not have a memory of the events due to intoxication. And I do have an affidavit of probable cause for the court.
Mr. Rolla, is there any objection to the no contest plea?
If she can't remember, Judge, I'm not going to object. As far as the affidavit, there'd be an objection for using it for plea purposes.
Thank you. Let's review that for a second. All right, based on the information within the report, the court finds that a no contest plea would be appropriate based on intoxication and lack of memory. So, Ms. Working, I want to make sure that you understand you're going to be pleading guilty to 1 count of resisting or obstructing a police officer. That charge carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine. You understand that?
Yes.
Are you currently on any kind of probation or parole?
No.
With that maximum possible penalty in mind, what is your plea to that charge today? Right now you have certain rights. I'm going to go through them with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself if you want it. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal it by leave, and that means that you have to ask the Court of Appeals to hear your case. If they say no, then you can't go any further with that appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this plea?
Yes.
I'm referring to the affidavit of probable cause. It's complaint number 25421-00415 from the Gaylord Police Department, City of Gaylord Police Department. Mr. Rolla, have you reviewed that document?
I have, Judge.
Do you agree that it would provide a factual basis for finding of guilt in this case?
I do, Your Honor. Thank
Mr. Trush, have you reviewed that?
I have.
Provide a factual basis.
I do.
Mr. Rolla, are the people aware of any threats, promises, or inducements of that must be placed on the record?
you. No, Your Honor, thank you.
Mr. Trush, are you?
I'm not aware of any, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in taking in this no contest plea?
Yes, Judge.
Mr. Church.
I am satisfied.
Right, working the court finds that your plea is knowing and voluntary. I reviewed that police report, or I'm sorry, the affidavit that I referred to. The court's going to mark and admit that as court exhibit 1. Court finds that the information contained within that exhibit would support a factual basis that you are guilty of count 1 in this case. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. Before you leave today, you're going to meet with Mr. DeLeo from the probation department regarding the pre-sentence report. It's important that you follow through with that process and that you stay in touch with your attorney prior to the sentencing date. Okay. Mr. Roll, anything further on this file? Mr. Church.
Nothing further. Thank you.
Thank you. That's all for today.
Thank you.
And we're ready on Mr. Krueger's case.
Yes, Your Honor.
Court of People versus Kenneth Krueger, file number 256832. The record should reflect Mr. Krueger is appearing today by video from the Sheboygan County Jail. If I can have counsel for your appearance now.
For the record, Your Honor, Michael Mertz, people.
Thank you, Your Honor. Richard Trushman on behalf of Mr. Krueger. Your Honor, this is our first hearing up in circuit court. I think we had a hearing scheduled about a month ago. There was some difficulties. I don't know if it was with the writ or with the jail, but ultimately Mr. Krueger was not brought up, so we weren't really able to do anything. I had an opportunity to talk to Mr. Krueger before this hearing. There are some issues I think we still need to sort out with this file. Mr. Krueger has indicated to me his anticipated release date from Sheboygan is, I think, about the middle of next month. So I would ask court to consider a 60-day adjournment, since I think it goes without saying, once he's released from Sheboygan, I expect my ability to communicate with him will be exponentially better.
Any objection to that, Mr. Rolla?
No, Judge, thank you.
Mr. Trush, have you been able to have enough conversations with the prosecutor and Mr. Krueger that do you believe this is ultimately going to resolve in a plea, or is it too early for you to tell that?
I think it's a little early to answer that.
All right, so we'll set this for a status conference in 60 days. Mr. Krueger, were you able to hear everything that your attorney said?
Yes, Your Honor.
Do you have any objection to proceeding that way with your case?
No, Your Honor.
Okay. So we'll send notice of the date and time of that hearing. Mr. Krueger, once you're released from the Sheboygan County Jail, let's see if we have an address for Mr. Krueger. Are you going to be returning to your address on North US Highway? Is that we're in Levering? Is that a good address to send the hearing date to?
Yes, Your Honor.
Okay. All right. Thank you. Mr. Rolla, anything further on this file today?
No, Your Honor, thank you.
Mr. Trush.
Nothing further. Thank you.
Mr. Krueger, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Okay. Just make sure that you stay in touch with your attorney once you're released from Sheboygan, okay?
Yes, Your Honor.
All right. Thank you. That's all for today. The court's going to disconnect at this time. Are you ready on Mr. Roll's case?
We are.
The court calls People versus Christopher Roll, file number 256812 and 256813. Rolling, go right to the podium there, and record should reflect that Mr. Roll is present here in the courtroom today. If I could have counsel for your appearance.
Record, Your Honor, Michael Mertz, people.
Thank you, Your Honor. Richard Trushman on behalf of Mr. Roll.
This is the date and time set for sentencing hearing in these files. And Mr. Roll, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Trush about that?
Yes.
Okay. Mr. Trush, are there any additions, deletions, or corrections that need to be made to that report?
Yes, Your Honor. The only change that I would make to the body of the report is CFJ 101, the basic information report. Lists him as Catholic. He reports he's Christian. So I would say more specifically, I think Christian is accurate there, not Catholic.
Objections to that change, Mr. Rowland?
None whatsoever. Thank you, Judge.
Any other corrections, Mr. Church?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rowland, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Judge.
Anything on behalf of the people for allocation?
Yes, very briefly. This is a situation, Mr. Roll, out on bond. In this particular case, injured both the victim of domestic violence as well as corrections officer May. He had a PVT of 0.12. Under the circumstances in this particular case, we think some jail time is appropriate, even though these are first felony offenses. Thank you.
Thank you, Mr. Church.
Your Honor, I think the recommendation here is appropriate. I certainly can understand the prosecutor's position, but I think as the court looks through this report, I think the report accurately captures what's going on here, which is there's a lot of contributing factors to what occurred here. And I think this story starts really with the death of a child and the impact that that had on Mr. Roll and on his family. And that caused a deterioration both of his relationship as well as led to his struggles with alcohol. And those two things kind of came together to create this situation. And what we had is after this tragic event, Mr. Roll and Ms. Dort, I think were both grieving in their own ways, and it had a toll on their relationship. The result of this, frankly, is I think both of them turned to substances, and the relationship became toxic. And this court's probably well aware, those substances certainly don't help that at all. The relationship continued to deteriorate. It's a situation where I think, as odd as it is to say, I think it came from a place of Mr. Roll trying to hang on to his family, trying to not lose his family. He'd already lost a child, and he didn't recognize what he should have, which is the relationship was bad. It was bad for Victoria, it was bad for him, and he should have got out of it. He should have got away. For both of them, for his sake, for her sake, but he didn't. You know, we're stuck in that push-pull where we know that we should do what's best for us, but in our heads we tell ourselves, you know, sticking it out for the family is what's important too. It wasn't a good choice, and it led him down a bad path. However, Mr. Roll has taken tremendous steps forward. He's addressing his issues. He's addressing the alcoholism. He's working with the men's group. He's doing the things we want to see him do. I would suggest to the court, I've been working with Mr. Roll probably for about a year now, give or take, and he's really getting his feet under him now. When I first interacted with Chris, he didn't have stable housing. He was basically living out of his van. He had a job, but it was kind of touch and go. Now he's in a much more stable place. He's getting the counseling. He's addressing some of these issues that are leading him here. I think it would really be a disservice to put him in jail. I think holding the jail in abeyance is a good way to keep the fire under his feet and keep him on the right path. And, you know, I guess from my experience with Chris, I can tell you he's a hard worker, and I think he will get in there and do the work if you give him the opportunity to do it. Thank you.
Thank you, Mr. Roll. Anything you wanted to say?
Yes, I do a PBTs every day. I'm doing my AA. I'm working with Bear River. She actually wrote a letter. I don't know if you would like to see that. So I have 2 counselors, and I'm doing my men's group. So we're working with Wellsprings to get my daughter back. I have a certificate of completion through Wellsprings for reunification. It's a 16-week course. I have my DBA now, so that I can go out. I do handyman work, so now I can do that. Yeah, I'm trying to move forward, keeping my head down, and just moving forward. I have stable housing now. I'm no longer living in my van. I'm staying with a friend, working with him too. I think that, if I do end up in jail, that's going to push me that much farther back and reunifying with my daughter. I'm so close. I feel like that would be just a step backward. I do agree that, holding that over my head, holding jail time over my head would keep that fire. But I believe going to jail would just be a step backward. I'm just trying to move forward with my life, and I guess that's it.
All right, I did read through the report, so I'm familiar with the circumstances in this case, these 2 files. I'm also familiar with your background, and your personal circumstances based on information in that report. And your past criminal history as well, which involves 2 prior charges of domestic violence. And so the court, taking all of that into account, along with what you had to say here today, your attorney, what Mr. Bolas had to say, I think there's definitely some mitigating circumstances and some aggravating circumstances here. First of all, my sympathies to you for the loss of a child. That's a terrible thing. No one deserves to go through that, and I can accept that people react a lot of different ways to a loss like that. It can be very difficult. And I don't think it's surprising necessarily that both you and your partner gotten more heavily involved in using substances to cope with that. I don't think that's unusual. I think everybody would acknowledge it's probably not the most healthy way to deal with it, but it happens. And I think it's understandable for that to occur, and, for things to go off the rails a little bit for a while, have a loss like that. And I think that's while it's not an excuse, it's a valid kind of explanation for that behavior. And it's apparent to me, based on what's written in the PSI, I had a chance to look at this letter that you submitted here today, that you are taking a lot of steps to try and move on from this, which is a good thing. That you're looking for healthy ways to deal with the loss and your underlying issues. But I also read the victim's statement in the PSI, and it's clear that this had a significant impact on her, this physical abuse that she was victim to, and she's asking the court to give you the maximum possible amount of jail time.
I know.
And so, this isn't necessarily all about what's best for you in this case. The court has to look at the community as a whole and what we do when people engage in this kind of conduct. The court has to look at the deterrent effect here. And it is significant to me that, you were placed on probation 2 times prior to this for the same type of crime. So you've had 2 chances now to correct your behavior and get on the right track. And again, that's not taking away anything from the fact that you're doing it now. It's a good thing. But I can't ignore the fact that you've had prior opportunities to do this and it hasn't worked. And so in my view, you've used up your chances to avoid jail time. And that's been based on your own conduct. You had opportunities to avoid going to jail twice. And for whatever reason, you didn't or weren't able to kind of heed those prior warnings. So at this point, I think it is appropriate to impose a jail sanction. But it's important to balance that with, again, the efforts that you've made, as well as the potential now based on those efforts for rehabilitation. So the court is going to, number one, I do think continued supervision is appropriate. The court's going to follow the recommendation in terms of probation. As to file number 256812, the court is going to place you on probation for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to order that you serve 6 months in the Otsego County Jail, credit for 2 days served. The court's going to order that you serve the first 90 days of that in the jail. The remaining 3 months can be served in the work camp program. A crime victims assessment of $130, a supervision fee of $30 per month while you're on probation, or a cost of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost. As to file number 256813, and 2 years probation, subject to all the terms and conditions listed in the report. Crime victims assessment of $130, $68 state cost on that file, 2 days in the Otsego County Jail with credit for 2 days served. You do have the ability to seek an appeal of these sentences, and Mr. Trush, if you could have Mr. Roll acknowledge you see those comments. Mr. Trush, did you want the Bear River letter attached to the PSI?
I did, Your Honor.
Yes, just this. That's to be served. Mr. Brown, do you have Mr. Hoover present? People versus Eric Hoover. This is file number 256840. The record should reflect Mr. Hoover's present here in the courtroom today. If I could have counsel put their appearances on.
Mr. Brown, yeah, Mr. Green.
Mr. Brown, can you tell me the status of this file today?
Your Honor, I've had conversations with Mr. Rolla. There is a plea offer in the matter. Going off memory here, but I believe it is to plead to count 1 count 2 and count 6 for dismissal of the remainder. There has been some indication that he would recommend or not object to day-for-day credit if Mr. Hoover could get into an inpatient center. However, I view that as more of a sentencing issue than part of the plea offer. We had a conversation with Mr. Hoover regarding that. I believe we are going to take advantage of that, please, but I will leave that to Mr.
Okay, and you indicated count 1, 2, and 6.
Yes, Judge.
Is that a correct statement of the plea offer?
It is, Judge, also with the $200 blood test fee pursuant to statute.
Mr. Hoover, have you had a chance to talk to Mr. Brown about this plea agreement?
Yes, Your Honor.
And do you want to accept that plea agreement today?
Yes, Your Honor.
You need more time to talk to Mr. Brown before you do that?
I don't believe so, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Where are you at? Mr. Hoover, are you currently on any kind of probation or parole?
No, Your Honor.
Okay. And so I'm going to go through the charges that you're going to plead to here, and I want to make sure you understand the maximum possible penalty you can face for each of those. So under this agreement, you would plead guilty to 1 count of resisting or obstructing a police officer. That carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine. Do you understand that?
Yes, Your Honor.
Would be pleading to 1 count of operating while intoxicated as a 3rd offense. And that carries with it a maximum possible penalty of up to 5 years and or a $5,000 fine. You understand that?
Yes, Your Honor.
And you would be pleading guilty to 1 count of operating a vehicle outside of what was allowed under your restricted license at the time. And that is a misdemeanor. It has a maximum penalty of up to 90 days and or a $100 fine. Do you understand that?
Yes, Your Honor.
With all those in mind, what is your plea to each of those charges this morning?
Guilty.
I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand that you have all of those rights.
I do, Your Honor.
Do you understand that by pleading guilty today, you're going to be giving up and waiving all of those rights?
I do, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. The only way you can appeal it is by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter into this plea?
Yes, Your Honor.
Are you pleading guilty to these charges because you are actually guilty of these charges?
Yes, Your Honor.
Information I have indicates this happened back on February 15th of 2025. Is that the correct date?
Yes, Your Honor. I thought it was the 14th, but
Okay. Somewhere in that range, though,
yes,
mid-February?
yes, Your Honor.
Okay. On that date, is this intoxication based on alcohol or something else?
106, Judge.
Okay. So on that date, Mr. Hoover, had you been consuming alcohol?
Yes, Your Honor.
And after you consumed alcohol on that date, did you operate a vehicle on M32 here in Otsego County?
Yes, Your Honor.
And did you have some blood or breath test done to determine the level of alcohol in your system at the time?
Yes, Your Honor.
Mr. Rolla indicated that result was 0.106. 0.106. Do you have any reason to doubt the accuracy of that test?
No, Your Honor.
And during the course of that, did you come into contact with Deputy Sheriff from Otsego County?
Yes, Your Honor.
And was that officer wearing his uniform at the time?
Yes, Your Honor.
Did you know that he was performing his duties as a police officer while you were interacting with him?
Yes, Your Honor.
And what did you do to resist or obstruct the officer?
I didn't get out of the vehicle when they asked me to, so they took me out of the vehicle.
Okay. So during the course of their investigation, they asked you to get out and you refused to do that?
That's correct.
At the time that you operated that vehicle on that day here in Otsego County, did you have some restrictions on your driver's license?
I did, Your Honor.
How did you violate those restrictions that day?
I wasn't driving the vehicle that had the interlocking device that was installed.
So your restrictions required you to operate a vehicle with the interlock and you operated a different vehicle.
That's correct, Your Honor.
Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge, thank you. As to counts 1, 2, and 6.
Mr. Brown?
Yes, sure.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on record?
None by the people, thank you.
Mr. Brown?
None by defense, and the court has complied with the court.
Mr. Hoover, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave here today, you're going to meet with Mr. DeLeo. He's going to set up a time for you to have a pre-sentence interview. And then it's important for you to stay in touch with Mr. Brown prior to that hearing, okay?
Yes, Your Honor.
Mr. Rowland, I think further action final today.
Not in this case, thank you.
Mr. Brown. Thank you, Mr. Hoover. That's all for today.
Thank you, Your Honor.
All right, let's take a short recess. We'll come back on the record and we'll stop that.
All rise.
Sir, are you Marcus Clark?
Yes, Ron.
We're on the record in People versus Mike Marcus Clark, file number 206002. Executive counsel, put your appearances on.
Thank you. The record, people.
Larry Brown on behalf of Marcus Clark.
This is a continuation of some probation violation proceedings in this case. Mr. DeLeo or Mr. Bola, how did you want to proceed today?
Your Honor, Mr. Clark just paid the balance in full on his fines and costs. He presented receipts to me this morning. So at this point, we would dismiss the probation violation and we'll be submitting our requested discharge as probation successful.
Okay, thank you, Mr. Brown. Anything to add to that?
No, Your Honor.
Okay, thank you, Mr. Clark, for taking care of that. It sounds like we'll be signing a successful discharge for you. Did you have any questions at all?
No, Your Honor.
Thank you for being here today, and you're free to go.
Thank you very much. You have a good day.
Thank you.
And what's your name? Alyssa Vanier?
Yes.
We're on the record in People versus Alyssa Vanier, file number 256855. The record should reflect the defendant is appearing today by video from Otsego County Jail. Oh, Mr. Church.
I'm right around. I think they had, it's regarding the talk.
Okay, great, thank you. Okay, Mr. Church, we have Ms. Vanier here on video from the jail.
Thank you.
Can I have counsel put your appearances on?
For the record, John McCall, that people.
Thank you, Your Honor. Richard Church, appearing on behalf of Ms. Vanier. This is date and time for a status conference, our first status conference here in the circuit court. I believe we do have a resolution of the matter whereby Ms. Vanier would admit a CSC 4th degree. The 2nd degree would be dismissed.
Mr. Church. I'm sorry, Mr. Rolla.
That's quite all right,
Monday
Judge.
morning.
I didn't want to interrupt.
Yeah, no, thank you.
Yes, it's a plea to the, would count to criminal sexual conduct 4th degree dismissal of count 1 criminal sexual conduct 1st degree as issued.
All right. Mr. Trush, can you outline the maximum possible penalties for that charge?
That should be a 2-year maximum.
And I can give that to the court right now if you'd like. Let's see if it opens up. There we go. It's a 2-year offense, and the penalties in addition to 2 years would be $2 years and or $500. There's mandatory HIV STD testing. Thank you, Judge.
Are there any sex offender registry implications to this plea?
Well, it's a tier 1 offense under the registration. If the victim is 18 years or older, it's a tier 2 offense if the defendant's prior conviction. And it's a tier 3 offense if the victim was was less between 13 and 17 or less than 13 years of age. So yes, Judge, there would be SORA requirements.
Have you gone through those with your client, Mr. Church?
We did discuss SORA.
Okay. All right, so Ms. Vanier, the plea agreement in this case would include you pleading guilty to a 4th-degree criminal sexual conduct, which carries with it a maximum penalty of up to 2 years in jail or prison. And in exchange for that, the more serious charge of 2nd-degree criminal sexual conduct would be dismissed. Have you had a chance to speak with your attorney about this plea agreement?
Yes.
And did you want to go forward with that agreement today?
Yes.
Can you raise your right hand, please? Sorry, your right hand. Go. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Vanier, are you currently on any kind of probation or parole?
I'm on probation, no contact.
Is that a bond condition, Mr. Trush?
Correct. I believe the no contact is just part of the bond.
Okay. Are you aware of any probation in this case?
I'm not aware of any.
So Ms. Vanier, as I indicated, the maximum possible penalty you can face for this charge of 4th-degree criminal sexual conduct is up to 2 years in jail or prison and registration on the sex offender registration list. Do you understand that?
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, your only way to do that is by leave, and that means that you have to ask for the Court of Appeals to hear your case. If they say no, then you can't go any further with that appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've discussed here on the record today?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes.
Right. Mr. Trush, there really is very little factual information in the felony complaint or information. Can you question your client?
I can. Ms. Vanier, can you hear me okay?
Yes.
So, Ms. Vanier, what is your relationship to Bentley?
His biological mother.
And did you live with him at 3229 Forest?
Yes.
That's here in Gaylord?
Yes.
And was there a time when he was in your care that you took his penis between your thumb and forefinger and stroked it?
Yes.
And that was for your pleasure, not his? I'm sorry, you kind of broke out. That didn't really come through.
Yes.
And at the time of that, was he under the age of 13?
Yes.
I think that would cover the full financial releases.
And the Bentley involved is Bentley J.
Oh, hold on a second. Let's not use full names.
Oh, I'm sorry, Judge. Yeah, my apologies. The people are satisfied with sufficient factual basis. Thank you.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor. Thank you.
Mr. Trush?
I am satisfied there's a factual basis and I'm aware of no threats, promises, or inducements.
And Mr. Rolla, are the people satisfied that the court has complied with statute or won't take this plea?
Yes, Judge.
Mr. Trush?
I am satisfied.
Ms. Vanier, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea. This matter will be set for a sentencing hearing. Between now and then, someone from the probation department will be in touch with you for a pre-sentence report. And you'll have a chance to discuss that, go through that with your attorney prior to the sentencing hearing. Mr. Rolla, anything else that we need to address for the record today?
No, Your Honor. Thank you.
Mr. Trush?
Nothing further, thank you.
Okay, thank you, Ms. Vanier. That's all for today's hearing, and we're going to disconnect at this time.
Okay, thank you.
I cannot see very well. Is that you, Mr. Papp?
Yes, Your Honor.
Okay, thank you. All right, we're on the record in People versus Carl Papp, file number 256857. The record should reflect that Mr. Papp is appearing today by video from Department of Corrections. If I could have counsel put your appearances on.
Yes, Your Honor. Let the record go, people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Papp.
All right, this is set for a status conference in this case today. Mr. Trush, can you tell me where this file is at here today?
Yes, Your Honor. So this is our first hearing after the bind over. From discussions with Mr. Papp, we're still waiting on transcripts from the preliminary exam, albeit they should be fairly short because although it was a lengthy exam, it was over 2 days and the first day of it has already been completed. So really it's just a smaller transcript we're waiting on, at which point we anticipate filing of some motions. So I would ask the court for some time to do those things.
All right, what's a reasonable time frame based on the complexity of the motions that you need to draft and file?
Given that we already have, again, kind of the bulk of the transcript, I suspect 60 days would probably be sufficient for me to get the rest of the stuff I need, get the motion drafted and filed.
Mr. Rolla, any objection to that?
No objection to the motion, but I would indicate for the record there was a plea offer, a plea to count one for dismissal and habitual court enhancement. Should the defense decide to go through with the motion, that plea offer would be withdrawn.
Okay. All right, we got that for the record. So, Mr. Trush, I'm going to then put in the pretrial order. I won't set any trial dates at this point, but the court will put in the order that any of the motions that you're aware of at this time need to be filed and set for hearing within the next 60 days. And then the court will set this for a hearing, a status conference at that 60-day mark, just in the event that for whatever reason there are motions that get filed prior to that. Mr. Papp, did you have a question?
Yeah, it was, I also wanted the transcripts for the arraignment with Judge Cooper, not just preliminary.
Okay, Mr. Trush.
I don't know if those have been ordered yet, but I certainly can make sure they do get ordered.
Because that's,
Okay, so-
that's the one I really wanted, because that's the one that showed where Judge Cooper violated my due process.
Okay, it sounds like your attorney's gonna make sure that those are ordered, okay?
All right, thank you, Your Honor.
All right, Mr. Trush, anything else we need to address for the record today?
I guess I would just sort of indicate to the court that the direct motion that I tend to file is a motion to quash the bind over, at least that's what we anticipate. There is potentially, I think, an evidentiary motion regarding a trial. I don't know if that's ripe yet, and I probably have to do a little digging to figure out when the appropriate time to raise that issue is, but I just put it on the record because I don't know that that's going to be ripe in 60 days. If it's not, I'll address it to the court at that time.
Okay, and I guess I can clarify too. I mean, I'm looking at this 60-day cutoff as, you know, as pretrial motions, not necessarily evidentiary motions that would address what could or couldn't be admissible at trial. So I'm just looking at preliminary matters. So, Mr. Roll, anything further I can address for you?
Your Honor, thank you.
All right, Mr. Papp, did you have any questions about how we're going to proceed?
No, Your Honor, but is there any way that me and Mr. Truce can get put into a breakout room?
Any other files, Mr. Trish?
I don't, but if the court has the time,
Yeah, I can put you guys, if you have something to sign in on.
yes, I can.
So Mr. Papp, your attorney's gonna sign in to Zoom here, and then I'll put the two of you into a breakout room.
Thank you, Your Honor.
Okay, Ms. Newsman, I'm just waiting for the other parties to connect here.
Thank you, Judge.
Mr. Backlund, are you able to hear me okay?
I am, Your Honor. Thank you.
All right, thank you. So we'll go on the record now. This is Pettit versus Pettit, file number 2520096. If I could have both counsel put your appearances on.
Good morning, Your Honor. Jennifer Dukeman on behalf of Jessica Pettit, who is present with me in my office.
And Zach Backlund on behalf of the defendant, Monty Pettit Jr., who is also appearing by Zoom. And I just filed my appearance this morning, Your Honor. I provided a copy to the office of Ms. Stutz-McCoy. It probably hasn't hit your file yet. So.
Okay, just 1 second. I just need to do something unrelated to this case here on Zoom. So just 1 second, counsel. Okay, Mr. Trush and Mr. Papp, I'm gonna create a breakout room and put both of you in that right now.
Thank you. Thank you, Your Honor.
Okay, we're back on in the Pettit versus Pettit matter. Mr. Backlund, thank you for that information. So the court will get you set as counsel for Mr. Pettit. This was set for a scheduling conference today, and I believe Ms. Stutz-McCoy, you had a motion notice up for a hearing today. Is that correct?
Yes, for exclusive use of the home, Your Honor.
Okay. Let's address that issue first. Ms. Stutz-McCoy, I don't know if Mr. Backlund, were you aware of that motion?
I am aware, and I've spoken with Ms. Stutz-McCoy about the motion, Your Honor. Yep.
Okay, Ms. Stutz-McCoy, has there been any type of agreement, or how did you want to proceed with that?
Well, Your Honor, I think at this point, we're going to have to proceed to an evidentiary hearing. There's some pretty serious allegations that we're making about Mr. Pettit's behavior and my client's need for the home. But unfortunately, it sounds like we do not have an agreement that she can have exclusive use of the home at this time. So I am asking for an hour evidentiary hearing on that as soon as possible.
Okay, Mr. Backlund, any objection to the time frame?
No objection to the time frame or the time requested, Your Honor.
Okay, so the court will set this for a 1 hour evidentiary hearing. I don't want to speak out of turn here without consulting with Jennifer, my assistant, yet, but I am aware, just based on my docket this morning, that some of my criminal matters for June are not going to be proceeding, so I may be able to get you a date like within the next 2 weeks or so. But again, I don't want to guarantee that, but I think we could probably do that. Ms. Dutzman Boyd, can you be ready within that time frame?
Yes, Your Honor.
Mr. Backlund?
Yes, Your Honor.
Okay, so I'm just going to put in the order set for 1 hour evidentiary hearing at the court's next available date.
Thank you.
And then that will be in person here at the courthouse, since it'll involve the taking of testimony and evidence, just so the parties are aware. And then did the two of you want to set some additional dates for going forward, or do we want to wait to have that hearing, Ms. Dutzman-Quay? What are your thoughts on that?
I think it would be appropriate to have a pretrial or status conference right now, Your Honor, if Mr. Backlund is prepared. I was simply going to ask for 90 days for discovery. We obviously haven't exchanged anything yet. This is a relatively recent case that's been begun. And so we would like some time to do that. And I think these parties would potentially be able to go to mediation. I don't have a problem with community mediation services if that's something that is all right with opposing counsel.
I'm okay with everything that Ms. Stutzman-Coy just said, Your Honor.
Okay. All right, so we'll set discovery to remain open for the next 90 days. Parties to participate in community mediation within that 90 days. And then the court will set this for a status conference at about that 90-day mark. If the parties were able to resolve the issues through mediation, then we can use that date to take proofs and enter a judgment. If not, then we can discuss further scheduling. Ms. Dutzman-Coy, any other dates that I can address for your side today?
Not for today, Your Honor. Thank you.
Mr. Backlund.
Nothing further, Your Honor. Thank you.
So I guess in terms of scheduling that motion, Ms. Dutzman-Coy, since it's your motion, I'm going to ask that you contact my office and get a date and time from Jennifer, and then notice that up for hearing with Mr. Backlund.
Absolutely.
Okay. All right. Thank you. Ms. Dutzman-Coy, anything further I can address for your side today?
Not today, Your Honor. Thank you.
Mr. Backlund?
Nothing else. Thank you.
Okay. Thank you. That's all for today. All parties on this file are free to disconnect at this time.
Thank you.
Thank you.
looks like we've got everybody connected. So we'll go on the record in Hayden Jones versus Munson Healthcare. This is file number 2319251. If I can have counsel unmute and put your appearances on, starting with plaintiff.
Jenny Sikorsky on behalf of the plaintiff, Your Honor.
Good morning, Your Honor. Rebecca Walsh appearing on behalf of the plaintiff.
Good morning, Your Honor. Ralph Faltucci appearing on behalf of the defendants. I believe that that's it. Okay.
See Ms. Greenman's connected, but I don't see, oh, there she is.
Yep, sorry, Your Honor. Yes, good morning. Jenna Wright Greenman on behalf of Otsego as co-counsel with Mr. Faltucci.
Okay, great. Thank you. We're on the record here today on plaintiff's motion to strike some amended disclosures and answers to discovery, particularly related to two of the doctors in this case. And so Ms. Walsh or Ms. Sikorsky, not sure who was going to proceed with argument on that today.
I am, Your Honor. Good morning. This is indeed our motion to strike supplemental disclosures, supplemental interrogatory answers, and an affidavit that was filed by the defendant Murphy. I'd like to just give a very brief historical element to put this in context, Your Honor. This case was filed in March of 2023. In December of 2023, the defendants filed their expert witness lists, naming who their retained expert witnesses were. In addition to, they did not name defendant Murphy. In addition to that, they named their lay witnesses and put asterisks by every single physician or healthcare provider, noting that any or all of those healthcare providers might give expert testimony as part of their lay witness testimony. On February 20th of 2024, defendant Murphy was deposed. She specifically said she hadn't received any tests, any of the tests that had been done at the hospital, had not received any reports. And in fact, that was the basis of her claim that she shouldn't be a part of this lawsuit because she hadn't seen the ultrasounds. She hadn't seen the Doppler studies. She hadn't even seen reports of any of these. Discovery closed by agreed to an order of this court on September 30th of 2024. In further order, the summary disposition and Daubert motions were filed on November 1 of 2024, were scheduled for hearing in December, but ultimately argued on February 7th of 2025. At the time of that hearing, the motion to dismiss defendant Murphy was denied. 2 weeks after that, the defendants filed a motion for reconsideration, amended disclosures, and amended interrogatories. On March 7th, they submitted an affidavit from defendant Murphy. In that affidavit, defendant Murphy said that the defense attorney had sent her these Dopplers and ultrasounds in January or February of 2025 and asked her to read them to give an opinion, in so many words. And that was after they had already filed their motion for reconsideration, Your Honor, when she filed this, when she submitted this affidavit. Discovery's done. We're trial ready. We have a trial date. We've cited a number of cases that say you can't create a new cause of action or a new defense to a case after discovery is closed. And this is way after discovery is closed. It's even after all the motions have been argued. We've cited several cases to support our position. The defendants did not respond to any of that, did not give us any case law to suggest that it would be okay this late in the game when we're ready for trial to create a new cause of action. And by create, I'm not suggesting, I don't have any information about how this all came about other than the lawyer sent this to the defendant after the summary disposition motions had been filed and perhaps argued, and then she came up with this new opinion. If they wanted it, and I guess I want to also address, because I think it's important that in their motion, they say that we agreed that discovery would go on until trial. but then they put the 3 little ellipticals and didn't put in the rest, that it was as to supplementation of the record. And as the court knows, the court rules are very clear about when you can supplement. It's not when you create new evidence and you want to create a new defense to the case. Its examples are things you didn't know or couldn't have known. Like if the plaintiff treats with a new treater after the close of discovery, then we have an obligation to supplement to tell the other side that so they know there's a new treater. It's not you go out and make a new claim, because they actually sent these to the witness, this defendant, to try to get new information from her. And that's not appropriate, Your Honor, at this point. And I also want to point out that this flies in the face of the admissions the defendants have made. We filed a discovery plan in this case, and we filed at least four amendments to it. And in each of these amendments, in the section of stipulations that the parties agree to, specifically paragraph 16, 17, and onward, for example, they agree that the Doppler studies show the SD ratios, resistive indexes, and pulsatility index were all elevated for the cord and mid-cord. They admitted that the baby was at the 4th percentile on various occasions. So these are admissions by the defendant. So now what they're trying to do is the defendant is trying to present evidence that she disagrees with her own admission. And once there's a party admission, that's an admission by that party that should be used against them and is allowed to be used against them through the entirety of the case. So for the defendant to now want to change what she's already, I mean, I don't even know how to word it. She's agreed to this, and now she's saying something completely different. In addition to that, Your Honor, she's saying something that contradicts every other treater in this case, every other expert in this case, and is I mean, she's like an island unto herself who wants to say these things are abnormal. If you very carefully read their retained expert's affidavit, he doesn't say that. He says that one piece of it or one slide of it is questionable, but that it does in fact show that there is an increased pulsatility at the mid-cord, he said for sure. So he doesn't even agree with her, with the defendant, in his opinion. They also want to say now, it appears through this same retained expert, that in fact there was not IUGR. But what he's very careful about the way he words it, Your Honor, whenever there's an ultrasound, they give you a number. And that's the number that you use to determine whether the baby is small. But there's always a range, you know, it's like plus or minus 100 or whatever it is. In this case, I think it was plus or minus several hundred. And he says, well, if you add on the entire plus to it, then the baby would not be IUGR. But that's not what the standard is. That's not what we questioned him. I mean, that's not what he said in his deposition. In his deposition, he acknowledged that these Dopplers were abnormal. He acknowledged that this baby was IUGR. And so the careful crafting of his affidavit and wording disagrees with some of his testimony, which is inappropriate, but for other parts of it, he doesn't say what the defendant's disclosures and supplemental interrogatories even say he's going to say. It in fact contradicts them. And Your Honor, this is highly prejudicial to the plaintiff. We're prepared for trial. Our experts have been deposed. We're now doing our preparation for trial. And now the defendants want to introduce an entirely new defense to this case that basically says all of the medical records and all of the experts who have testified and all of the treaters are all wrong, including the co-defendants must be wrong. That's not appropriate, Your Honor, not this late in the game. And among the potential remedies, Your Honor, I can't think of any other remedy other than, I don't think that default is too much, I would think. But other than dismissing this attempted new defense, Your Honor, there's really no other remedy for this that would be fair to the plaintiff. I mean, the defendant said, well, you could depose these 2 witnesses again, but again, that's not fair to us because we've already deposed them. And introducing technicalities about how a Doppler study or an ultrasound was done would necessitate hiring new experts, would necessitate going in, looking at, doing discovery about their equipment. and would take months and months and months. And this case is already almost 2.5 years old, Your Honor. And that would not be fair to the plaintiffs at all. They deserve their day in court. We've got our trial date and we're already preparing for trial. We don't want to go back and have to start doing discovery on new issues again at this point, Your Honor. And it would be very unfair to the plaintiff and prejudicial to the plaintiff to do that.
All right, thank you. Mr. Valatutti, response?
Yes, Your Honor. What the plaintiffs are asking for is 2.313 parent B 2B sanctions for the defendants supplementing their discovery responses. The rule says that in the case that a defendant fails to supplement written discovery responses, which which are recognized as incomplete or incorrect if additional or corrective information has not otherwise been made known to the other parties during the discovery process. So in other words, we supplemented our discovery responses. We supplemented the answers to interrogatories, and we supplemented it not only in form of an answer to interrogatories and in the form of disclosures, which the rules allow for. In fact, the supplementation of disclosure rule was amended in, I think, 2020, and there was a great deal of discussion with regard to the purpose of that. It was recognized that discovery depositions don't end discovery. Many things are uncovered after discovery depositions, which under old practice were not disclosed and were merely put in evidence at the time of trial. The new rule says, no, you're not going to put evidence of anything in at trial if you haven't supplemented your disclosures. Now, what was the reason for this supplementation? Let's go back in time. We originally complained of the plaintiff's complaint because, notwithstanding the fact that it was 100 paragraphs and more than almost double that if you include the subparagraphs, they did exactly what the case of Dacon versus Transu teaches against, which is alleging everything in general, but nothing in particular. I went through the discovery deposition of their expert and committed him to the fact that the sole action or omission alleged, or at least spoken of, was that there was something wrong with Dr. Murphy's consultation. But in his discovery deposition, after going back and forth with him over the order that she wrote, he agreed that she did not violate the standard of care. Plaintiffs in their papers, in response to my motion for summary judgment for Dr. Murphy, they alleged that Dr. Murphy had a duty to become aware of the February 4th ultrasound report. And ultimately, that was taken up by the court on page 14 of Your Honor's opinion, which was entered, well, the hearing occurred on February 7th, and the opinion, the transcript was made that same day. And at that time, Your Honor said, look, and I think you correctly recognized the issue in the case, primary issue in the case. The issue comes up with this. The issue comes in is what happened after that. So, Your Honor, up to that time, there's no allegation against Dr. Murphy for doing anything right or wrongly after her consultation. But in any event, you indicated that it's not whether or not she was aware of abnormal testing on the 9th. What she should have done is say, okay, if the tests come back as A, then you need to deliver at B. If the tests come back with C, then you need to deliver at D. And the motion was, the defendant's motion for summary judgment regarding Dr. Murphy was denied. I didn't move for reconsideration of that ruling by the court. I moved for reconsideration of the ruling of the court with regard to the matter of striking Dr. Her name's escaping me for the moment, but Worth. After the hearing on that, I contacted Dr. Murphy and I said, well, look, the issue is, what would you have done if you had seen the films? Now, I sent her the films. She looked at the films. She said, these films are read incorrectly. They don't show that there was either a decreased SD ratio or that this baby is needing to be delivered before the scheduled delivery date. That's a fact of the case. It's for the jury to determine. 99% of the plaintiff's argument goes to inconsistency in testimony. Well, that's preserved for the plaintiff to cross-examine Dr. Murphy. But the fact of the matter is, it is an issue in this case that needs to be resolved by the jury as to whether or not, as plaintiff alleges in their reply to the motion for summary judgment against Dr. Murphy, should she have been aware of these ultrasound reports, and what would she have done? Well, she, in her affidavit, said, look, I wouldn't rely upon these reports. They've been wrong from the start. And she looked at the film. There's a difference between an ultrasound report and an ultrasound film. And the ultrasound films were read wrong through the entire case. And that's evident in the case because after the reading of the 4th percentile, Dr. Murphy, 1 week later, performed her own ultrasound exam and saw the little girl was at the 27th percentile. And after that, no one was paying attention to the Otsego radiologist because they're not obstetrical or maternal fetal medicine specialists. And let me address this matter of prejudice. Under the stipulated order we have before the court, the parties on page 11 of that stipulated order, the following is found. The parties have agreed that written discovery may continue up to any time before trial to accommodate the parties' requirements to supplement disclosures and responses made to written discovery that was complete at the time made, but required modification as time progressed. That's in concert with MCR 2.302E, which imposes upon the parties a duty to supplement. And that duty to supplement is, under the rules, is with regard to information that becomes known that was otherwise not addressed during the discovery process. So we, in February and March, supplemented our discovery as we were required to do under the rule. If we had not done that and merely established that testimony at the time of trial, then plaintiff would have had a legitimate objection under Part 302E, subparagraph 2. But for our failure to supplement, but we did supplement. Plaintiff wants to have the court enter 313 type remedies for our supplementation, not our failure to supplement. And the supplementation is timely. The supplementation occurred in March. The amended disclosures, well, the affidavit was made in March. the amended disclosures were made in February, and all of them were made within a couple of weeks of the experts looking at the films themselves. And here's another thing that I wish to raise. It didn't occur to me when I was taking Dr. Bocor's deposition that he was serious, or what the seriousness was of his answer on page 69 or whatever it was that I attached to our papers, that all these readings are wrong. He said that. It makes me think he's seen these films. But in any event, the films are the real evidence. If, as in the Badalamenti case, the expert had disregarded, I have it reversed. In the Badalamenti case, the plaintiff's expert disregarded the films, the cardiac tests. In this case, our experts have looked at the films, which become important because the Otsego radiologists were reporting that this baby was declining in growth, and in fact, it wasn't. The actual evidence in the films is that the baby was maintaining a normal SD ratio throughout the entire period. That is to say, the blood flow to the baby was normal right up to February 4th, and that's their answer to Your Honor's question. What would they have done? You'll note in Dr. Murphy's affidavit, paragraph 7, she says she would not have relied upon the reports. She would have wanted to see the films herself. Let me see if I have that paragraph cited correctly. So all of this that plaintiff is arguing to Your Honor, she says, I routinely insist on reading ultrasound films and Doppler waveforms myself before referring OBGYNs or before further advising OBGYNs. All the plaintiff is saying is, well, this is inconsistent with that, and that's inconsistent with this. Well, I disagree entirely. It's not, and there aren't any inconsistencies. No one says they previously read this film and the films are correct. The reports are what they are, and were admitted to state what they state. But the films themselves are the best evidence of what the real growth of this child was and where she stood on the 4th of April, when plaintiffs, or not 4th of April, 4th of February, 2 days before the baby was delivered. And that's why we supplemented our the matter as quickly as we did, as the issue before the court required us to confer with our client and our expert as to what they would have done. You know, Dr. Landon thought that Dr. Murphy was a part of some team and that they were all in communication with regard to these films. They weren't. She was an independent physician at a different institution, and she is like Dr. Landon and MFM, and they read ultrasound films all the time. And she identified in various of the films that the operators, the technicians who were doing the measurements of these films, were putting the calipers on the wrong parts, coming up with the wrong numbers. And so the baby is as close to not being growth restricted or being growth restricted solely on the basis of whether you go with the ultrasound dating of the ultimate the delivery date, or if you go with the last menstrual period. Plaintiff contends you should follow the last menstrual period. We say no, you should follow the ultrasound dating because that has only a 0.9% chance of being incorrect, whereas the last menstrual period is plus or minus 14 days. of being incorrect. You would always use the ultrasound as to what the actual measurement of the baby is at the time in any kind of time-based projection as to how the baby's growing over time. Those are all questions for the jury. Plaintiff wants to create in front of the jury a scenario that is untrue. And I can see why they're doing it, but it has nothing at all to do with a full and complete hearing of the evidence, nor the fair administration of justice. If plaintiff thinks they have all of these inconsistencies, well, they have all these inconsistent statements, I guess, that they can bring out before the jury. The jury is the ultimate determinant of the credibility of the witnesses. The issue for the court is whether or not our supplementation should be stricken, and we contend it would be legally impermissible to strike a supplementation that is required by the Michigan General Court Rules up to and including the time of trial. Now, when would a supplementation be untimely? Well, I'll give you a concrete example. The last record we have of Peyton Jones' independent school reports is from September of 24. We're coming up for trial in October. Plaintiffs have not supplemented any of their discovery regarding the plaintiff's present condition, nor have they supplemented any of the discovery as to whether or not she can talk or where she is in school. And if plaintiffs go to trial and they seek to put in evidence regarding her condition without supplementing their disclosures, then I would have a valid reason to prevent them from doing it at the time of trial because they haven't supplemented their discovery as they're required to do. I think it would be reversible error, Your Honor, to preclude the defendant from filing a supplemental response, especially under these circumstances where the supplementation goes to a matter of fact and not a matter of opinion. It is films in the film, the X-ray films are evidence in the case. What the plaintiff really wants you to do is preclude the admission of the films themselves. She just wants to rely upon the wrong interpretation of the same and create a fiction that nobody was following at the time. And the jury will be instructed that the standard of care is to be determined based upon the facts and circumstances, the evidence of what was really going on at the time. And the best evidence of what was really going on with regard to Peyton Jones' size and blood flow to her brain 2 days prior to delivery is the film that shows she had good blood flow to the brain and was, depending on what dating you used, not a child that required delivery.
Okay, thank you. Ms. Freeman, did you have anything to add?
No, Your Honor, I concur with Mr. Valetuti's argument.
Okay, thank you. Ms. Walsh, anything in response? You're muted.
I'm sorry, yes, and I'd like to start by apologizing because I was incorrect about who the subject of the motion for reconsideration is. So I admit I was wrong about that and I apologize. But I want to go back, the supplementation of interrogatories or supplementation of your disclosure requires you to supplement if something is incorrect or is incomplete. It was not incorrect that Defendant Murphy did not see any of the films. She did not see any of the reports. That's not incorrect, and it wasn't incomplete. That's exactly what happened. They made it incomplete by doing some affirmative act that changed their whole posture of the case, Your Honor. That's not supplementing something that wasn't there. That's creating something new so that you can say you need to supplement it, which is absolutely inappropriate under the rules for supplementation. When Mr. Valetuti read your ruling, you said basically what the claim is that She should have known these, should have gotten these studies or reports. And if they said A, you do B. And if they said C, do D. That's exactly what it was. Going back in 2025 now, after discovery's closed and motions have been heard, and saying, now I'm going to show you this, that's not telling what she would have done back then, because back then she didn't do it. She didn't ask. It was curious that she filed an affidavit under oath that said she insists on doing it every time when she didn't do it in this case. So she didn't even do what she now claims as her norm. But back then she admitted she didn't have any of these things. And her opinions in this case and what she said in this case should be based upon what she said and knew during discovery, not upon new information that was created by the defendants. And I wanted to just share with you two things, because the defendants have pointed out what Dr. Bulker said repeatedly, but they haven't told you what he really said. What he said was, they were asked about a certain measurement, and he said, I think there's an error in the measurements, and the first percentile could have been the third percentile, and the ninth percentile could have been the seventh. So I'm sorry, seventh percentile very easily with different, so they're all very similar. They're all less than the 10th percentile. So what Dr. Bulker said was, you know, do you want to question me that did somebody who measured, you know, this length from in this number of centimeters or millimeters, did they miss it by one and it might have adjusted slightly? But his answer at the end of the day is, it was all below 10th percentile, which means this baby was IUGR. Then I want to read to you from, this is their expert, Dr. Manning, who they've talked about today. This is what he testified to under oath in his deposition during discovery. On December 13th, the ultrasound that was performed showed that the estimated fetal weight was in the 7th percentile, correct? And he asks what date, and we tell him, and he said yes. On December 13th, the estimated fetal weight was on the 7th centile. And that meets the definition for IUGR, doesn't it? Yes. He was asked on about that same, on another one. Let me see what date it was. December 31st, he was asked about it again, and he said that's correct. It showed that the ultrasound showed that the estimated fetal weight was in the 4th percentile. That's correct. And he agreed that was IUGR. Then the question was, on December 31 of 2018, she had an abnormal Doppler study, true? True? And the answer was yes. She had an abnormal SD ratio. That's correct. And an elevated SD ratio, that is determined to be an abnormal finding, isn't it? And he says, well, that's a critical point. I disagree with that. So he can say that that's not. But the point is, we asked him what the study showed, and he told us what he saw, what those studies showed. So if he had those studies, which he did, and he gave us an opinion about those at his deposition in the summer of 2024, now we have one person who's going to come in 2025 and say it's different. And Your Honor, this is not an issue of supplementing something that you knew or should have known. This is an issue of creating something new because you don't like the way the case is going. And the defense should not be allowed to create a new defense that has not been brought forth at any time heretofore, just to create a fact question where there isn't one, particularly where they've already stipulated that these tests were abnormal and that this baby's weight was less than the 10th percentile.
Okay, all right, thank you. I did have a chance to review the briefs that were filed by the parties on this issue, as well as all the exhibits that were attached. Obviously, I've considered the oral arguments here of counsel on the record today, which are largely consistent with the written arguments. I guess I view this really more as more of a procedural issue than I do as a substantive issue. In other words, the quality or the nature of these supplemented informations and opinions versus whether or not they're in compliance with the court rules and or whether they should be excluded as a violation of the court rules, or because at this point their disclosure would be prejudicial, so prejudicial to the plaintiff's case that they should be excluded. And you know, a large portion of both counsel's arguments here today on record and in writing go to really the quality of the new opinions as opposed to the procedural admissibility under the rules of discovery. And, you know, I think based on what I'm reading and seeing, plaintiffs may have a great deal of fertile ground to attack these disclosures and new opinions for the reasons that have been argued by Ms. Walsh here today. They can use them to impeach defense witnesses. To the extent they contradict other evidence, they can certainly point that out and argue the credibility of these new disclosures and supplements. And certainly, again, I think there's fertile ground to do that, but I think there's a difference between the character of that evidence and whether it should be excluded as inadmissible for violating the rules of discovery. And in this case, I find that it should not. Again, most of the plaintiff's argument goes to the quality of these new opinions, not to whether or not they violate the rules of discovery. And the court's role as in ruling on a motion like this, in my view, is not to weigh or judge that evidence, but to determine whether or not it's so violative of the rules of discovery that it should be excluded. And, you know, I get plaintiff's argument here that, you know, this isn't really a new disclosure, and in that way it's not really a supplement, and that they're creating something new because they don't like the previous answers or opinions. But again, the discovery rules, I don't think require the court to go behind the nature of the supplementation. The whole purpose of discovery is for both parties to timely disclose information to prevent unfair surprise at trial. And when we look at the overall purpose of discovery here, regardless of the character of the supplements, they clearly have been provided far enough in advance of trial that it wouldn't be an unfair surprise to the plaintiffs. And in fact, I mean, I think Ms. Walsh has developed some really good points to raise. So I mean, that just, again, illustrates to me that plaintiffs aren't being you know, unfairly caught off guard here, that they've already had an opportunity and will continue to have an opportunity to attack these supplementations. Trial is set for October 23rd, so we're still more than 4 months away from the trial date. And even though plaintiffs haven't had a ruling on this motion until today, or won't have had that, they certainly have had the information for much longer than even the 4 months. And so it still has an opportunity to depose these witnesses, to bring out those contradictions if they choose to. And these are going to be limited issues of supplementation here. So it's not like the plaintiffs are being presented with entirely new witnesses or experts or something like that. I mean, these would require limited inquiry by the plaintiffs to get the information that they want or need. So for all those reasons, the court finds that, number one, that the defendants have supplemented their answers. They supplemented them in a time frame that doesn't present some type of unfair surprise to the plaintiffs, and in a time frame where the plaintiffs, in my view, aren't prejudiced by the disclosure and have adequate opportunity to prepare for those new disclosures. And again, whether or not the plaintiff has good arguments to impeach or discredit those at trial before a jury, they'll have an adequate opportunity to do that, but I don't find that those would be reasons to exclude them under the rules of discovery. So for all those reasons, the court will deny the motion, and Mr. Valatutti, as the prevailing party, I would request that you prepare an order and submit that to the court under the 7-day rule.
Your Honor, could I just be clear that the order should also allow us to do any discovery we would like to clarify these new issues?
Yeah, yes. I mean, I don't think the court has to reopen discovery necessarily to the extent that it's closed, but I think plaintiffs should have the opportunity to inquire into the supplementation, just as as the other side would. So, yeah, absolutely.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. That's all for today. All parties are free to disconnect on this file. Thank you.
Thank you.
You.
That concludes the court's morning docket. The court will be in recess.